So I got more common legal myths that we're covering today. The first one is SLAPP makes it very difficult to win defamation lawsuits. So first of all, SLAPP stands for Strategic Litigation Against Public Participation. So that's actually the evil part, right? So what actually makes it difficult to win defamation lawsuits, if this myth were true, would be anti-SLAPP lawsuits. So anti-SLAPP lawsuits make it more difficult. So basically what the SLAPP is, for example, if you have a corrupt governor and the media is trying to tell stories about it, then the governor uses their power over judges and their finances to file defamation lawsuits against the media. So that's a SLAPP lawsuit, strategic litigation against public participation, trying to stop the public participation. Well, the anti-SLAPP lawsuit is written to offer some protections for the media. So if they accidentally print something that's not true, then they're not going to get sued. So that's why the anti-SLAPP lawsuit basically then requires that the governor prove that the media published it purposefully, knowing that it was false. So it adds some protection against mistakes. So if we apply this to Chile's lawsuit for defamation against Josh and Kate, it doesn't really apply because the anti-SLAPP lawsuits in California, although it's one of the states with the most protections, it's only for lawsuits against matters of public concern. So, public concern is basically anything that has to do with our self-governance. So when you say like we're government for the people by the people, right? So any participation that Chile had in our governance as a person would be relevant. And it doesn't even matter if you're a public figure or not. So, for example, if Chile had a contract to teach constitutional law to police officers, his reputation then would be a matter of public concern, whether or not he was a public figure or not. But it doesn't apply at this time, at least, to Chile. I mean, he is doing nothing that involves the self-governance of the country. All right, so the next one is you can't bill someone for services provided without an agreement. So the Latin phrase is quantum meruit for this. It basically means that you definitely can enter into a inferred agreement without agreeing to the prices or the cost ahead of time. And then you're pretty much obligated to pay a fair price. So, I don't know, Google it. All right, so when someone is wearing two ankle monitors, it means they're the most violent and dangerous criminals. So this myth is a lot different than the other myths I've been covering lately, but this one came up and I thought it was interesting. So I don't know. I heard some Karens say it, and it's not the case. So when you see someone with two ankle monitors, one of them is going to be the GPS monitor that tracks their location and possibly enforces their home arrest or whatever, and the other one is going to be a blood alcohol tester, continuous one. So I don't know. It depends on whether you think someone who's committed a DUI is a violent and dangerous criminal. But in general, it's someone who had a DUI and they're on parole or probation, or even out on bond, and probably they were initially given the opportunity to blow into a tester, and they weren't following their bond or parole requirements in doing that, so things got escalated, and now they have a continuous blood alcohol monitor on their ankle. So that's why they have 2 ankle monitors. All right. So the last one is the founder of an organization isn't responsible for the actions of the members. So I've heard this a lot to do with Chili's case against Kate and Josh, even though, harassment hasn't been added yet to the complaint. So the myth is not true. So under the common law doctrine of agency, there rises the principle of vicarious liability. And the easiest way to explain this is, for example, someone who doesn't do most of their own work is still responsible for that work. So let's start off with a corporation first of all, right? So Intel as a company doesn't do anything, right? Everything it does is through its employees or agents. So that doesn't mean that Intel as a company, can't commit a crime. It can. It's just going to be through its employees or agents. And then that's true for a lot of other founders and owners of companies that isn't, a non-person entity. So, for example, Kate, right? And so some of the tests for agency are, first of all, right, Kate doesn't have to order the crime. She only has to authorize it. And it seems when you're not telling people not to do it, you're pretty much authorizing it. And when you get together as a group to commit harassment, it's pretty much authorization is pretty much in the charter. And then, and remember, only one of these needs to be true, and it seems like most of them are true. I'm going to read some more. So did she benefit from the crimes? Yeah, I mean, she's enjoying the harassment that's going on. She's also gaining financially from it. So were crimes committed while participating in organization activities? So were the members participating in the organization that Kate runs while the activities were occurring? So since, again, it's the charter basically to harass people, or especially Chile, then that one rings true as well. And then another one is, were the means used to commit the crime provided by Kate, right? So basically, like a police department could be responsible if a police officer uses one of the vehicles to commit a crime. There's some vicarious liability there. Well, a lot of harassment is being facilitated by the Discord server, which Kate owns. So I think that's 4 for 4. So again, this is I'm saying this is one of my bonus ones because I do cover some of this stuff in my recent video on class defendants. So I'm link to that one. Have a good day, everyone. Bye.